Hello and welcome to Permitted with Conditions, a podcast and newsletter that talks about zoning, land use, planning, housing, and economic development. I'm David Toyer, your host and the president of Toyer Strategic Advisors, a land use and economic development consulting firm north of Seattle. Back on February 7th, we put out a newsletter article, Should a River Have Rights? Examining the rights of nature movement and a recent ballot measure in Everett, Washington. It's become our most viewed post. Because of the popularity, we wanted to turn it into an audible edition for one of our podcast episodes. Should a river have rights? Everett voters said yes. Now what? In full disclosure, I led the campaign against the initiative discussed below. Voters approved Everett Initiative 24-03. A group of Everett residents affiliated with Olympia-based Standing for Washington gathered signatures in the summer of 2024 to put a ballot measure in front of Everett's voters. The measure asked whether the Snohomish River watershed, including Port Gardner Bay, should have legally enforceable rights. And on election night, November 5th, 2024, Everett voters overwhelmingly said yes. Here's the ballot title and summary. City of Everett Initiative 24-03, recognizing legally enforceable rights for the Snohomish River watershed. This ordinance would grant the Snohomish River watershed legal rights that could be enforced by any resident of the city of Everett. Anyone who negatively impacts the watershed's ability to exist, regenerate, or flourish would violate this right and could be liable for damages, which would be paid to the city to use exclusively to restore the watershed and repair any damages. Violations would need not be proven to a scientific certainty. Should this ordinance be enacted into law? The impetus for this ballot measure is the little discussed rights of nature movement, a less mainstream environmental viewpoint that argues all laws are man-made laws, and thus they're created to violate nature, not protect it. The rights of nature movement poses that a law or laws of nature are needed to counterbalance that equation, to act as a trump card, no pun intended, that allows individuals and groups to override existing laws, even without scientific proof, because they're dissatisfied with the outcome. How Everett became the target. Standing for Washington started off 2024 working to gather signatures for ballot measures it planned to run in Tumwater and Olympia cities near the state capital. These initiatives would have granted legal rights to the Deschutes River and the Bud Inlet. However, as they researched the initiative powers of other cities around the state, the group discovered that Everett, Washington's seventh largest city, had an ultra-low threshold for signatures. Additionally, one of Standing for Washington's co-founders had an acquaintance in Everett that they could reach out to for help. Alas, in May-June of 2024, they shifted all of their resources to Everett, where they secured just enough valid signatures, right as the deadline approached. With the vague explanation in the ballot title and summary, it's really no wonder Everett voters approved the initiative. I mean, who doesn't want to protect the environment or have clean water or hold polluters accountable? However, for those who read the finer details of what was actually enacted by the passage of the initiative, which full text we include below, it's clear that the initiative creates several serious problems. First, the initiative does not enact any new environmental standards, nor does it empower the city of Everett to enforce any differently its current regulations, nor adopt any new regulations to enforce. Instead, the initiative grants permission to private parties having a legal standing in Everett to file lawsuits that allege violations. They can file these lawsuits against groups, individuals, and even the city of Everett. Second, the initiative fails to define what constitutes a violation. Simultaneously, it lowers the burden of proof to be a mere probable violation, regardless of whether scientific evidence fully supports the claim. Third, it encourages frivolous lawsuits because, in addition to a lower burden of proof, the initiative also entitles successful plaintiffs to recover litigation costs, including attorneys' fees and expert witnesses expenses, creating an economy for lawyers and consultants that see this as an opportunity to make money. In sum, the initiative establishes no new protections for Snohomish's watershed, but it does enable lawsuits that are based on suspicion and presumption rather than facts and evidence. So, how could the initiative impact the city of Everett? While the initiative grants no power to the city of Everett, it does require the city to accept damages awarded from successful litigation. It also requires the city to spend those court-ordered damages on completing restoration work to the pre-violation condition. However, because the city is not exempted from being sued, Everett could ultimately be sued for not doing that restoration work fast enough or not doing it in a manner that's sufficient enough to bring it back to the pre-violation condition. Worse yet, it doesn't take into account that Everett, before it could do the restoration work, would have to seek a number of local, state, and federal permits to make that work possible. And the initiative doesn't prevent the city from being sued for carrying out its normal municipal operations. For example, during the campaign, I produced a short video explaining just one of the ways the initiative could be used against the city to challenge the city's current operations of its stormwater system. Here's that video. Hi, I'm David Toyer, a small business owner here in Everett, and I want to explain to you how Everett Initiative 24-03 will result in litigation against the city of Everett that increases your taxes and fees, something the proponents deny. When the rain falls in Everett, it's eventually collected and captured by stormwater infrastructure that treats and conveys the water back to the Snohomish River watershed. Some of this infrastructure is privately owned and maintained, such as the detention pond in your neighborhood, but most of the infrastructure is owned by the city of Everett. Even your neighborhood's pond flows into the city's infrastructure. Now, stormwater has become a major focal point for environmentalists. Groups like Earth Justice are fighting for more stringent stormwater controls, and they've declared existing infrastructure deficient in treating for things they believe may potentially hurt fish or whales. So it won't be long before we start to see lawsuits against the state and cities, lawsuits that seek the courts to order improvements to existing facilities and municipal wastewater treatment plants. Everett Initiative 24-03 lowers the bar for these lawsuits to be filed. It makes it easier to sue the city of Everett for violating the river by alleging that the city is not adequately treating storm and wastewater. Specifically, the initiative would lower the burden of proof to not require evidence that demonstrates scientific certainty the city's infrastructure is the problem or that upgrades are the solution. That puts the city in legal jeopardy, and it puts you, the taxpayer, on the hook. To give you an idea of what this could look like, I want you to flash back to a court case in 2016, known as the Culvert case. It was a decision that went against the state of Washington. and the court required the state to improve Fisk passages by replacing hundreds of highway culverts statewide by the year 2030 at an estimated cost of $3.7 billion. Money the state has since diverted from major transportation projects, including road widening and investments in its ferries. In March of this year, the Seattle Times reported the actual cost of culvert replacement was now estimated to cost the state and its taxpayers $7.8 billion. So passing Initiative 24-03 will put a target on Everett's back. It will bring with it lawsuits alleging the city's stormwater system and wastewater treatment plant failed to protect the quality of water in the Snohomish River watershed. And if the city loses, the courts will require Everett to invest hundreds of millions of dollars into replacing and upgrading storm and wastewater treatment infrastructure, all at the taxpayer's expense. That means diverting money from essential public services and increasing the taxes and fees it charges its residents and businesses through higher property taxes and higher monthly water and sewer bills. This will affect fixed income households the most. Times are already tough for the city of Everett and its taxpayers, and the cost of living has gotten out of control. We can't afford Everett Initiative 24-03. And that's why I'm against it. And I urge you to vote no on November 4th. Thank you. Such a challenge would be disastrous, considering Everett faced a $12.6 million budget deficit in 2024. After voters rejected a property tax levy lid lift and the adoption of the 2025 budget had to include deep cuts to both parks and libraries. Everett's adopted budget for 2025 also projects a $4.6 million gap between revenues and expenses, which the city hopes would be covered by the fund balance it anticipated by the end of 2024. So how does this impact housing? According to both the movement itself and environmental policy experts, the fundamental goal of the rights of nature movement is to stop development and, where possible, shut down existing businesses that are viewed as impacting nature. For example, Dr. Aaron O'Donnell, a world-renowned expert in water policy and a senior lecturer and ARC research fellow at the University of Melbourne Law School in Australia, stated during an interview with KUOW 94.9 that, quote, there will absolutely, if it's successful, if the rights of nature is successful, there will be impacts to development because that is exactly what it's trying to achieve. So how does this impact missing middle housing, or really any housing to be created in Everett? As a Tier 1 city, Everett is required under House Bill 1110, passed in 2023, to adopt new development regulations that allow at least 4 dwelling units per lot, 6 dwelling units per lot when transit is available. In adopting HB 1110, the legislature preemptively restricted challenges to new zoning regulations through administrative or judicial appeals. However, the legislature did not apply the same exemption to future building permits. That means that while a future fourplex may be exempt from SEPA challenge, the builder, developer, and/or the city could still be sued under provisions of Initiative 24-03, potentially stopping housing projects before they even begin. What does this mean for other cities? The initiative passed only in the city of Everett, and in theory, it applies only to those parts of the Snohomish River watershed and Port Gardner Bay that fall inside the city limits of Everett. However, water's not stationary. Thus, actions upstream in the river basin in places like the city of Snohomish, the city of Monroe, the city of Salton, and so on, may be subject to litigation under Everett 24-03 based on the allegations that actions outside the city of Everett violated the rights of the river inside the city of Everett. So, what's next for this movement? Standing for Washington on their website proclaims Everett's victory is just the beginning. They want to push the rights of nature initiatives to be in every city and county in Washington that allows for direct legislation by the initiative power. They're even offering a model ordinance to be used, and they're extending their support to help local groups customize these ballot measures. Additionally, Standing for Washington wants the Washington State Constitution to be amended to grant legal rights to nature. For that, they're actively working with the Green Amendments for the Generations organization on the addition of a Green Amendment to the state constitution. And last session, they worked with Representative Lenkoff on House Joint Resolution 4210, which, if passed, would have required approval of 2/3 the vote in both houses before being sent to the voters for ratification. Everett Initiative 24-03 has been challenged in court. On January 28th, 2025, a coalition that included the Master Builders Association of King and Snohomish counties, the Washington Aggregates and Concrete Association, several Everett businesses and residents, filed a lawsuit in Superior Court challenging the validity of Initiative 24-03 and seeking an injunction to implementation. You can read their complaint below. Their suit alleges that Initiative 24-03 is unconstitutionally vague, that it conflicts with other state and federal laws, and that it exceeds the local scope of initiative powers. It cites a Washington State Supreme Court decision in Spokane Entrepreneurial Center versus Spokane Moves to Amend the Constitution, in which the court found that a similar initiative in Spokane, granting the Spokane River rights, was contrary to state law. Final thoughts. Everett voters may not have fully grasped the implications of Initiative 24-03 when they approved it. But as the city now faces a legal challenge, potential financial hardships, and development challenges of its own as it seeks to build a new stadium for the Everett Aqua Sox, it now remains to be seen whether what's happened in Everett will become a cautionary tale for other communities or prove to be the first domino that falls in a broader movement that sweeps across Washington state. I want to thank you for tuning in to this episode of Permitted with Conditions. You can subscribe to the Permitted with Conditions newsletter on Substack so that you don't miss any content. Additionally, you can listen for episodes of this podcast on Substack and follow us on Spotify and Apple Podcasts. We welcome your feedback and ideas for future episodes. Thank you for listening.